Hello, good afternoon, and welcome to The Law. In the course of this week, we have heard the Attorney General suggest that or announce that some persons who are accused of some wrongdoing, economic crimes, corruption, are approaching the Attorney General and seeking plea deals to plea bargain. The OSP has also been to court and secured conviction for 6 persons who have paid monies in exchange for their liberty. They have been convicted, but they have not been sentenced to jail because they got into plea deals. That's plea bargain. What is the plea bargain regime here in our country, and how effective is it in our criminal jurisprudence after it got a 360-degree formalization in Ghana in 2022? This is what we seek to bring some light on. So join me right now to learn more and how you, if you got into trouble or someone around you got into trouble, you could access plea bargain. You don't go to jail, even though you admit to committing a crime. We'll be right back. I'm Samson Ladi Anyanini. This is The Law. It is your legal light. It is your health law. Welcome back. And this afternoon is going to be very interactive, so get ready to join us with your questions and also your contributions as well. We are talking about plea bargain. We want to understand what exactly plea bargain is and how you may access plea bargain. So, there's been a lot of talk about it, particularly heading to the elections in the United States of America. Trump got into all sorts of trouble right after he lost the elections earlier in 2020. His company, the Trump Towers, got into all sorts of troubles, tax issues, among others. And it appeared the only way he could save himself was to cut plea deals. So he was getting plea deals all over the place. As you see in your shot, Manafort forfeits $22 million in New York real estate in plea deal. Yes, connected to the Trump and his problems. There was Cohen, who was a good friend of his, but who had to find a way out when he got into trouble. And he had to do a plea deal to check out. Trump's campaign chief to help Mueller inquiry. I'm using this to tell you a story because plea deals are real. Cohen pleads guilty and details Trump's involvement in Moscow Tower projects. Yeah. And they talk about from loyalists to enemy, the evolution of the Trump-Cohen relationship. In fact, millions were spent in cutting plea deals so that jails will be avoided. Here in Ghana, not long ago, someone asked the question, is Atu Asian the first to have taken advantage of the plea bargain regime? And there was a reason for that question. That was when Atu Asian, having gone through a trial in the collapse of the Capital Bank matters, having gone through a trial for a long while, at a certain point decided that he was going to take or make a plea deal. So there was a plea bargain, and in that plea bargain, he was charged. The charges he was suffering, he was supposed to pay a total, or the amount involved was a total of about 90 million Ghana cedis. And that is what they came to agree will be the plea deal. So he agreed to pay the money so that he doesn't go to jail. He managed to organize some 30 million or so. But he couldn't pay all of it. Because he couldn't pay all of it, it means he couldn't fulfill the deal. He had to go to jail. But even in going to jail, he got terms that, according to the court, were softer because he had cut a plea deal. I'll just read a part of that story for you. It says that an Accra High Court had on Tuesday found him guilty after retaking his plea to make effective a plea bargain agreement. Essien pleaded guilty to various counts of conspiracy to steal, stealing, and money laundering. The court convicted him on his own plea. The court then accepted an agreement Essien reached with the state to return 90 million in 3 installments. He has reportedly paid 30 million already. The court also banned Essien from holding a key position in any financial institution. However, 2 others standing trial with Essien, Tetenete and Reverend Fitzgerald Odonko, were acquitted and discharged by the court. So, when we hear the Office of the Special Prosecutor in the course of this week go to court, and as a result of the court process, securing convictions for 6 people, what it simply means is that those people appear before the court, accused persons, who are accused in the GES payroll scandal. There's a payroll scam that the certain persons within the Ghana Education Service, some at the very top, some who have, knowledge about the deep dealings in how recruitments are made at the GES, were involved in doing recruitment for teachers and non-teaching staff for, various educational institutions through a fraudulent scheme. They get people to pay money. And as we understand, when one of them appeared before the court and was granted bail, it was said that in excess of about 6 million or so had gone through the person's account. 6 million Ghana cedis had gone through the person's account through this particular scam. The people that the person got sort of recruitment for through a fraudulent process were paying about 10,000 or so each for that purpose. So some of them, 6 of them, the OSP has been investigating them. And at the end, they decided that they would take a plea, they will either make a plea bargain. So they made a plea bargain, and on the basis of the plea bargain, they were put before a court. They were asked, how do you plead? You are accused of stealing X amount of money from the state through this corrupt process. So they have to answer, I am guilty. Once they say they are guilty, the court convicts them on their own plea of guilt. The natural thing that should follow is that they will have to be thrown into jail for the various offenses they are accused of. But they don't get to go to jail. because they have made a plea deal and they have paid monies. In the year 2015, there was a national service scheme scandal involving allegations of, thievery in millions of Ghana cedis. The Attorney General, together with the BNI who were involved in that investigation, announced that they had retrieved over 30 million Ghana cedis. How they retrieved it included plea bargains. Some of the people who were accused appeared before court and said, "I'm guilty. I'm not going to fight it." And on the basis of that, they were convicted, but they were not sent to prison. Get ready to join us to share whether you think this is a good thing or it is not a good thing. It is not only in Ghana that plea bargains or plea deals are made. As I mentioned to you earlier, in America, it is very rife, and they make plea deals on a daily basis, prosecutors. Elsewhere in the world, they make plea deals on a daily basis. Now, let me take you through a bit of our legal regime, how we have come from to this point. We began sometime in 1993, but I'm taking you through a couple of slides I have to show you how the plea bargain process is done, so that if you got into trouble with the law, or if a relation of yours or somebody close to you got into trouble with the law, and you assess the situation and the circumstance, you can decide for yourself that you want to make a plea deal, and to watch and see if that will be accepted or it will not be accepted. So on the screen, I'm going to take you through what I have labeled 360 degrees of plea bargain in Ghana. We have what we call the OSP Act. That's the Office of the Special Prosecutor Act. It was passed in 2017. It was a major plank of the Akufo-Addo campaign before the elections of 2016 or even 2012. Because he had been found that we are not able to deal with corruption holistically, because attorney generals are deemed to belong to the party. They sit in cabinet with people who are in their party, people they know. And so when they commit offenses, party people and so on, party financiers, it's difficult for attorney general to be able to prosecute them. So we should give a special power to a special prosecutor who is not in the government, who may not be associated with any political party, so they will be able to deal with these criminals. So that's how come we came to pass the Special Prosecutor Act. And in the Special Prosecutor Act, in 2017, it was the first time in Ghana's legal or jurisprudence we formalized the plea bargain regime. Until then, we had a law in 1993, but we didn't exactly, make it blunt that this is called plea bargain. But it was an opportunity, or there was a room for you to be able to do something close to plea bargain. But it was limited, very limited and restricted in some sense. And I'll take you there shortly. So in 2017, we eventually formalized plea bargain. And in Section 71 of the OSP Act, let's read together. It says that a person under investigations or charged with corruption or a corruption-related offense may voluntarily, please underline that. So a person under investigations, the words are intentionally chosen. You are under investigation. You have not yet been put before court. or you have been charged. Yes, you may be charged, but you have not been put before court yet. But when we say charged, often it comes with the notion that you have already been put before court. So when an investigation is ongoing, before you are put in court, or even when the investigation is over and you are put in court, or you are put in court and it's still ongoing, for a corruption or corruption-related offense, you, the accused person, may voluntarily, on your own free will, admit the offense and make an offer of restitution. An offer of restitution. Restitution, no any other way to explain it. It's try to bring maybe the person you have offended back to the place where they were before you offended them. And in this situation, often it will be the state. So if that's what it is, let's say you are accused of corruption in the amount of 100 million Ghana cedis. So you voluntarily admit the offense and then you make an offer to return the money. I'll explain to you later that it's not always the case that you return the exact same amount. In fact, often it's not returning the exact same amount. You pay the amount and then you make actually what we call real restitution. You pay extra money in exchange for your liberty. Or admit the offense and offer to provide information that will aid in the arrest and prosecution of other persons whom that person knows have committed or are about to commit corruption or a corruption-related offense. So it could be that you are giving back money. It could be that in addition to giving back money, you are going to provide supply information to the prosecutor, or that no money is involved, but you are giving important information, what we call actionable intelligence, or real, as it were, evidence of wrongdoing. You know some people. It is possible that you didn't commit the crime alone. You committed it with several other people, one or more people. You have been arrested. Those people have not been arrested because there's no trace or trail to them. So they have escaped. It could be that, say, you are working in a government institution. Perhaps it was the bigger boss, the minister, or somebody who got you to do what you had to do for them, and then you got caught. Meanwhile, you only got, the crumbs out of it. You didn't get much, but they got the bigger money. But you are the one whose signature is found on the wrong deal. And so you are arrested and you are being prosecuted or you are being investigated. You could give information with evidence that nails the other people, and that will be the basis for which there can be a plea deal so that we let you go, the prosecutor will let you go in exchange for catching the bigger thieves, so to speak. Right. Then it says also where a person under investigation or charged with corruption or corruption-related offense under this act makes an offer to provide information in accordance with paragraph B of subsection 1, the information shall be provided confidentially. So the information you are giving, because we need to protect you from the other people, that you have been involved in with this crime. It could be a crime that was committed, underworld, so that they don't come at you. Perhaps they may look for you to want to kill you and so on and so forth. It's a cocaine deal, and these things are done in the cover of darkness. So it will be, the information you are giving will be taken and there will be confidentiality to it, to the special prosecutor and the court. To the next section, where an accused person makes an offer of restitution, the special prosecutor shall consider if the offer is acceptable to the prosecution. So whilst the law says it is your decision to make voluntarily whether you are going to plead guilty or make a plea offer and make restitution, it is for the special prosecutor to determine whether what you are offering is acceptable. If they don't accept it, they won't let you walk, so to speak. They won't let you go get convicted and you walk. No, they won't do that. They will say, we reject it. So it happens. Sometimes, and often as we hear elsewhere in America, you will find that it is the prosecutors that are rather making the offer to you and asking you to accept the offer because they feel that they don't gain much taking you to court, prosecuting you, putting you in jail. They don't even gain much. But in your case, you are able to help them to trace other people and recover a lot of money to the state, which if they put you on trial, they'll get you convicted, put you in jail, and they won't get the money anyway. So they will make the offer to you, and then you will accept the offer in consultation with your lawyers. Then in 4, it says, in making the determination whether the offer is acceptable, the special prosecutor may consider factors including the history of the accused with respect to criminal activity. So, if it is the case that this is what you are used to doing, the special prosecutor may say, no, we won't just take money or take information from you and let you go. Because we find that you're a hardened criminal. You have repeated this crime over and again, and so you are making it like a business. We will not do that. It's just like in a normal criminal process. When we find that you are someone who is known to the law, that is to say that you get into that trouble, often, it gets you into bigger punishment. Your punishment gets enhanced. The level of cooperation the accused exhibited during the investigations. So if while they were investigating you, they were interrogating you, you were very cooperative, you didn't try to evade, you were forthcoming in assisting. You are showing remorse. Because some people, they are actually not, criminally minded. Some people, it is by, call it mistake. Some people, it's a temptation that they got into, and later they only regret. And so it's okay to give them, a second chance, so to speak. So the level of cooperation of the accused exhibited during the investigation, the willingness of the accused to cooperate in the investigation or prosecution of other persons. It could be that the special prosecutor wants to use you as a witness because the other bigger fishes they want to prosecute whose offense threatens the state, the security of the state, or whose offense have caused such huge economic loss to the state. Without you, without your testimony, it may be difficult to get those people, convicted in a trial. So they will have to check your willingness to cooperate in the investigations or the prosecution of the other persons. So you could enter into a deal. I will testify against these people. Yes, of course, I'm the one who did this for them. I was the one who took the money and went to this place. I'm the one who was giving the bomb to go and place it in the car, that kind of thing. And when I was doing it, I even took a picture of myself, or I took a video of myself. I know every move. I sat in ABC meetings when, all the planning was ongoing. The conspiracy was ongoing. We did this, we did that. It can point you to various bank accounts, that monies have been taken into. So it helps. Okay, so in the GES recruitment scandal, you can see the special prosecutor has information and is telling that this particular account, X amount went into it. And this is how often amounts went into that account. It is telling you that the people who have been convicted, who did a plea bargain, obviously gave good information. they will go seize property, they will go and, as it were, place a freeze on bank accounts and seize money and all of those so that it doesn't get dissipated. Is it something good, you think? So we'll be opening the phone lines soon for you to join. But let me move on to the next law I want to share with you on the matter of plea bargain. And so in section 71, clause 4, it says that they will also consider the likelihood of obtaining a conviction if the case proceeds to trial. Sometimes they can weigh the circumstances and say, well, this case we have some evidence, but when we go to trial, criminal trial, the burden on the prosecution is proof beyond reasonable doubt. Like we always say, proof beyond all reasonable doubt. And the law says, when there is a small doubt in the prosecution's case, it must go in favor of the accused. A small doubt in the case you are doing, it must go in favor of the accused. So they can weigh it and say, well, prosecution may take too long, it may cost us so much, and we may not get much. Maybe in the end, we may not even get conviction. It doesn't look like we may. It's sort of a chance game. But if we confront the accused with this, they may be willing to do a plea deal. So they will do that. The probable effect on witnesses of a trial, they'll consider that. The public interest in having the case tried rather than, going for a plea bargain. So they don't just decide that because you have money to give us or because you're giving us a lot of information, we will, let you plead guilty, you get convicted and you walk. No, they don't do that. Disposed of by a guilty plea and the need to avoid delay in the disposition of other pending cases. I think I spoke about that earlier. Now I'll take you to this other provision, and we scroll up. So I take you to this other provision quickly so we can now proceed to the taking your contributions and your comments as well. If the offer is not acceptable to the prosecution, the investigation or case before the court shall proceed. So if they don't accept it, the case will go on. If the offer is acceptable to the prosecution, the special prosecutor shall, in the presence of the accused person, inform the court, which shall consider if the offer of restitution is satisfactory. So there's some checks and balances. You don't leave it to just the prosecutors, so that the judges will come in as well, so that people don't end up cutting deals, leaving their friends off in the name of plea bargains. So judges will have a role or a say in this matter. Let's go to the next slide and where the court considers the offer to be satisfactory, the court shall accept a plea of guilty from the accused person and convict the accused person on that plea. And instead of passing sentence on the accused person, make an order for the accused person to make restitution. And an order of the court under subsection 7 is subject to the conditions directed by the court. Right? Where a person convicted under this section defaults in the payment of the money required of that person under this section, or fails to fulfill a condition imposed by the court under subsection 8, the court shall pass a custodial sentence on the accused person. Even though in Atuesian's case, he didn't use this particular procedure, but you realize the same thing happened. Some who make a plea bargain can pay all the money up front. some may not be able to pay everything upfront. And you see, as a state, you don't want to leave the money for them to dissipate it. So if they have half of the money, you take it. Because if you don't take it, it will go waste. They may spend it. And then you give them a period. So in Esian's case, he was asked to pay the 90 million in three installments, separate installments. Then he paid up to 30 million and had difficulties moving forward. So you will see that eventually the plea did not work. He was convicted, he was sentenced to go to jail. That's what this provision is saying here. It doesn't mean that if you don't fulfill the conditions that you promised, you will still go free. No. If you offered that, you will testify. If you offered that, you will come to court and help the state to catch the bigger fishes and get them guilty, and you then decline, or you begin to do things that don't further that process, your plea will not work. Now, let me take you to 1993. So I said plea bargain was formalized in our legal jurisprudence in 2017 through the Office of the Special Prosecutor Act. But in 1993, we had what we call the Courts Act. And we made a provision that actually offers you the opportunity of a plea bargain, even though in a different sense. It says, where a person is charged, and this is section 35 of that act. So plea bargains that have been made before 2017 and 2022 especially were made under this law. The ones you have heard about, the National Service scandal in 2015. At the time, the Special Prosecutor Act had not been passed. At the time, the plea bargain law, the full comprehensive law, which was passed in 2022, had not been passed. So you come under this law. It says offer of compensation or restitution. So you see, it doesn't call it plea bargain like it does in the Special Prosecutor Act. It says, where a person is charged with an offense before the High Court or a regional tribunal. Now mark that. What it meant previously is that to be able to, as it were, be amenable or have the chance of a plea deal, or call it offer of compensation and restitution in exchange for your liberty, you would have been charged with an offense before the High Court or regional tribunal. So if you were charged with an offense before a lower court, circuit court, district court, it will not be available to you. That's what this law meant. The commission of which has caused economic loss. That's important too. That the crime you have committed for which you are being charged has caused economic loss. So it must have some, economic significance, not some petty crime, so to speak. Harm or damage to the state or any state agency. So if it has caused harm or damage, that has to be a damage to the state or a state agency. The accused may inform the prosecutor whether the accused admits the offense and is willing to offer compensation or make restitution and reparation for the loss, harm, or damage caused. So this was the previous law we're using. Let's move on now to the very latest. Okay, let me just read portions of this also to you. Where an accused makes an offer of compensation or restitution and reparation, the prosecutor shall consider the offer, consider if the offer is acceptable to the prosecution, just like we have done in the OSP Act. If the offer is not acceptable to the prosecution, the case before the court shall proceed. If the offer is acceptable to the prosecution, so we seem to have just picked what we have here in 1993 and slapped it on the OSP provisions. Now, I'm bringing you to 2002, and then I'm going to open the phone lines for you to join, and let's have a conversation. Let's hear your views about whether it's a good thing that people commit crimes, and we make them give us information or intelligence. We make them help us to catch more people, and then we let them go, but we convict them. We don't put them in jail, or we take money from them, compensation, restitution, or reparation, so to speak. And often that maybe, you may call it interest. We take the quantum and we take interest. Sometimes it can be double the amount that you are accused of. It may be more than double the amount you're accused of. It is how you value your liberty. That you're going to go to jail for, say, 25 years, and you have committed an offense that involves stealing, corruption involves stealing of 1 million. And the prosecutor says, if you give me 3 million, I'll get you convicted, but you not go to jail. It's up to you to decide if you will take that up or you will not. Now, in 2022, we finally came to a decision that we needed a comprehensive law in our regime, in our jurisprudence, to take care of plea bargains. So, led by the Honorable Attorney General, Godfrey Dame, this law was made. It's an amendment to an existing law, and it was done in 2022. It says, subject to Section 162B, a person charged with a criminal offense may at any time before judgment, so if you are charged, it's important to note that you have been charged with a criminal offense, but you may at any time before judgment. So some people have expressed misgivings that the trial is almost at the end. In Atuesian's case, for example, they said, but the judge had finished. He was just about to give judgment. Yes, the law says at any time before judgment. So the opportunity is available to you at any time until the court has given a judgment. So if today is the day the court is coming to give judgment, you can show up and say you want to negotiate with the Attorney General on a plea instead of having the judge read the judgment. And that's what happened in the Atuesian case, right? The law allows it. You have sort of arrested the judgment to allow for the opportunity to plea bargain, do a plea deal. Because you see, the lawmaker recognizes that maybe at the beginning you felt you had a good case. Maybe at the beginning your lawyers advised you that, there's a certain strategy we can take which can assist. From where they are coming from, it doesn't look like they have this evidence. From where they are coming from, it doesn't look like they have this witness. And without this particular evidence or this particular witness, they cannot convict you. They can't get a conviction against you. Because in criminal law, your offense must be proved beyond reasonable doubt. And they cannot do it. If there is a scintilla of doubt, the law says it must inure to your benefit so that you will work rather than getting convicted. But in the course of the trial, as things are moving on, people are being cross-examined, witnesses are coming in here and there. People you thought may not testify have suddenly decided to testify. It could be that they are testifying for you to strengthen your case, or they are testifying for the Attorney General or the state to strengthen the state's case. It could be that at the beginning you felt you get someone to help you and the person was not willing. You are looking for a document and the document was not available. And so you felt if you go through, you'll be in trouble. So you did the plea. It could be that it was the other way, that you felt they don't have some things. But in the process, you found that the way things are going, you will end up in jail. So you're allowed any time before judgment is pronounced. And that can be the very day that was set for judgment. You negotiate with the Attorney General for a plea agreement. And this is what can happen if you negotiate for a plea agreement. It can lead to a reduction of the offense charged or a lesser offense. Maybe you were being charged with an offense for which the maximum jail term is 25 years. You could make a plea, make some payment or give some information or do anything that the prosecutor requires of you. And that will lead to reducing the charge to one that could get you to a maximum maybe 10 years or a maximum 3 years. It's possible. It could actually get you to a maximum 1 day. Yeah. So if you do that, it says can lead to a reduction of the offense charged and a lesser offense replacing that, or it could lead to a withdrawal of the charge against you, the accused person. The charge can completely be withdrawn. Then you are free. Which means, in this case, charge has been withdrawn. So you are not going to be pronounced guilty, convicted, or anything. It's possible that that can happen. To reduce the punishment for the offense charged within the law that prescribe the punishment. I think I have mentioned that already. You will be very lucky if your plea led to a withdrawal of the charge. That's one you go free, completely free. It is as if you were never put before a court. Because if the charge doesn't get withdrawn, you get a lesser charge, you get lesser punishment, or even you make payment, you are convicted but you are not put into jail, you still carry that tag, ex-convict. Yeah. And that's what all of us want to avoid. I'm opening the phone lines now. You can join us. I'm going to share with you certain offenses in this law for which you will not be allowed to do a plea bargain. There are certain offenses, like sexual offenses, defilement, rape, murder, those offenses. No plea bargain for you. All right? Okay, so Osman, where are you calling us from? Let's hear what your contribution or question is.
I'm calling from Tamale.
Yes, Osman.
Please, I want to know, supposing your case is already taking place or your judgment has already taken place, then later you were told about this plea bargain. Can you come back to the court for the plea bargain again?
Absolutely not. Once judgment has been given, the case is closed. There's no opportunity for a plea bargain for you. Thank you, Osman. Who is next? Right. So that's how plea bargains, as far as we have come to do them in this country, that's how they work. So take note of it in case you have someone who gets involved in a situation where they feel that the best thing for them is to go and ask for a plea deal. Seth, you're calling us from Kumasi. Let's hear you.
Okay, so my question is, on the last day that the judge is to read the judgment, you said even up to that morning you can still negotiate for a plea. So if on that day the Attorney General decides to say no, what happens? He says no.
If the Attorney General, Special Prosecutor, BNI, or whoever they are, once they say no, it is a no.
Okay.
Right. Right. Thank you very much, Seth. Who is next? You can make a contribution. You can ask a question. Hello, George. Joshua. Hi. Hi, Josh.
Yes.
Yes, go ahead.
Yes, something. I want to find out from the plea bargain whether through the case management conference, when you see the evidence the prosecutors have against you, can you ask for time in terms of the judge forcing the prosecution, that's the case management conference, for you to have a negotiation with the prosecutor to come back?
Okay, so George, I understood you, but I did explain earlier, as the law was very plain on its face. You're talking about case management conference. Case management conference means the trial has not even started. Until judgment is rendered, you have the opportunity to approach the prosecution and say, I beg, I don't want us to go on a trial. I want to plead guilty. And you see, in these cases, because you have already been charged, it is possible that you have already pleaded guilty, not guilty, on the first day you appeared in court. The court will ask you, these charges have been slapped on you, how do you plead? And normally what you're supposed to say to the court is, guilty or not guilty. There are circumstances where you may say guilty, but the court will now hear you and find that you are exactly not guilty, but you are pleading guilty, and the court will assist you to plead not guilty. So if you have already pleaded guilty, in the course of the, not guilty, sorry, if you have pleaded not guilty, in the course of the case, you can approach the prosecution for a plea deal, and once the plea deal is agreed between you and the prosecution, you and your lawyer and the prosecution, then you go to court and say you want to change your plea. And you can do that on the very morning of the judgment being rendered. And it will be taken and you could survive. Hello, Fatao. I'll take you first before I go to Prince. Hello, Fatao. Is Fatao still on? Hello, Prince.
Yes, sir, something. Good afternoon.
Hi. Good afternoon. Go ahead with your question.
All right. Thank you
your contribution.
That you always give. I'm so impressed about it. Through you, some of us have been able to speak out because the little laws that we've been learning from, although we are not lawyers. Thank you for that. But my question here is, I don't know, maybe economically it makes sense. But don't you think also that it seems like this law has been specifically been made for the elite in the society, if I can put it that way? Because most of the times I visit our lower court and sometimes see people being jailed for so many years because they went to steal a plantain, cassava, somebody's maybe goat or something of that sort, and been jailed for so many years. And this topic, discussion has come out severally that such petty offenses, at least individuals can be made to go through, let's say, the society, maybe doing some cleanup and other things, but it has not been considered. But why is that this plea bargaining in the last Attorney General's reign, he was able to go through this seamlessly. And to me, it seems although economically it's better, it helped the country or the state to get some money that is enormous and that can be used to develop the country, although it is good.
I think your point is made. I think your point is made. Give other people the opportunity. Thank you very much. So, you see, we started from 1993 and we limited it to economic crimes and crimes for which the harm and damage is to the state or to a state agency. Then we came to 2017 in the OSP Act, and we made provision for it for corruption offenses or corruption-related offenses. Then in 2022, we did a 360-degree and made provision for it. And even in 1993, remember, your offense must be one that goes to the High Court or the regional tribunal, which is actually like a high court. because they operated parallel with the High Court. And now we make this and we don't say where you should go and ask for and so on and so forth. So it's available to you once you open yourself to it. Once you get to know, you can suggest to your lawyer when the thing happens, because you know your lawyer doesn't know. It's what you tell your lawyer that your lawyer deals with. Remember, lawyers take they take instructions after giving you the client's advice. Yes, sorry for keeping you on for too long. Yes. Alex, go on.
Okay, something. Good afternoon to you. My question is this. The plea bargain has been applied, and happens to be that the prosecution later on finds out that it didn't really go as they wanted it to be. The prosecution then call back the plea bargain, or would it go through to an appeal?
All right, so once you enter into a plea, it's a decision you have made, and that's it, it ends it. And from the 2022 law we made, you actually cannot appeal the decision unless under very, narrow circumstances, which I should share with you before we end. Who is next? Hello, Andrew.
Yeah, good afternoon.
Mm-hmm. Go ahead.
Yeah, you said if the judge wanted to give you a plea and then the prosecutor said no, what will the prosecutor say if the judge see the case? The person say, oh, I'm sorry that I don't know this because I'm not a lawyer, I don't know anything about this, but this is what, and because of this, I'm sorry. And maybe the prosecutor is demanding something from you, which you are saying maybe that you are right, or this, I didn't do the thing. And now the judge is saying that if they should give you a plea or do the prosecutor say no, where will the judge not go into it and understand?
If I understood what you said, once you get your lawyer, explain to your lawyer your circumstances, your lawyer will assist you. If a prosecutor, you are dealing with just a prosecutor and you show up in the court, it's an open court and you are always asked to speak openly in the court. So you can tell the judge that this is the circumstance. Plea bargains are not forced on you. So I hope that helps. Yes, who is next? Hi, Ruben.
Yeah, good evening.
Go on with your question or your contribution.
I was saying this will be a very preventative because when you take our prison, people go there, after going there, they went and enjoying our resources and come back and continue with the same problem that takes them there. So I think, plea bargain were having to about get more money from their side. But I want to ask a question too. My question is, what of if in a case with a prosecutor, and it's like the prosecutor can pay also make a plea bargain?
Okay, thank you very much. The plea regime, everything you are dealing with, you know that in a criminal case, you are always dealing with prosecutors. The prosecutors need to refer the matters they are dealing with to the Attorney General for whatever has to be done. And it is advised, you should always make sure you have a lawyer assisting you in the process. Now, in the new regime, you cannot ask for plea bargain if the offense you are charged with is treason or high treason. If the offense is what the law calls a high crime, rape, defilement, genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking, and an offense related to public elections. An offense related to public elections. Who is on? Hi, Clenham, right?
Yeah.
Yes, go ahead.
Yeah, good afternoon. Clenham from Akama. Please, I want to know cases that affected plea bargaining So I want to know, and I also want to ask, is there a court, the court system that we have that plea bargaining affected all the court system, only specific court system?
Okay, so the list I gave are the cases for which there will not be a plea bargain. Beyond that list, every other charge in this republic now, from the 2022 law, you can have the opportunity of a plea bargain. But remember, there are considerations that the prosecutors must take. They have to accept it. If they don't accept it, it doesn't work. They take it to a courtroom, and the judge may have an opinion about it. The plea process must not be fraught with fraud. Let me read section 162M, setting aside judgment. It says, where 162L before, it says finality of judgment. Where a court convicts and sentences an accused person in accordance with a plea agreement, the conviction and the sentence shall be final, and appeal shall not lie against the judgment of the court. That's what I said earlier. There is no plea. A prosecutor or an accused person may at any stage of the proceedings withdraw from a plea agreement before the plea agreement is accepted by the court. So the only time you can withdraw from the plea bargain agreement is when it has not been accepted and judgment given. I have said that also. Now it says a prosecutor or an accused person may appeal to the court to set aside the judgment on the ground that the plea agreement entered into was as a result of fraud, misrepresentation, undue influence. So if you were unduly influenced, mistake, you made a mistake in entering the plea agreement. Duress, you were forced, duress, force against your will. Illegality, we find that there's some illegality on it. And incapacity on the part of the person other than the person making the application, or in breach of the rules of natural justice. So these are also the only conditions under which you can file an appeal, and the process will be set aside. So this has been the law. It's your legal light. It is your help law. Plea bargain 360. I hope we have been helpful to you.